This is Michael Popok, Legal AF. Steve Bannon is about to lose his appeal. Remember Steve Bannon, podcaster, QAnon, MAGA right-wing person, conspiracy theorist, consultant for Donald Trump during the coup, and tried to avoid having to testify to the Jan 6 committee, both providing documents and actually giving sworn testimony. Well, he got convicted by a jury last July, July 2022, and he got sentenced a few months later by Judge Nichols for a 4-month sentence. But some people might be thinking, well, I don't remember Steve Bannon going to jail. It's because he didn't go to jail because Judge Nichols, who, yes, is a Trump appointee, D.C. Circuit Court judge, decided that the issue of whether Steve Bannon could assert the reliance on advice of counsel. In other words, he followed the direction of his lawyers to not respond to the subpoenas and just flout and thumb his nose at Congress, whether that was a legitimate defense in the District of Columbia or not. And along for the ride was the issue that we've been talking a lot about on Legal AF, which is whether Donald Trump, when he was no longer president, whether he could still assert executive privilege when he was the executive of the land. And even if he could, does it apply to somebody like Steve Bannon, who is no longer working in the White House at that moment, but was as a podcaster? So what we like to refer to it on Legal AF, that leading podcast on the MeidasTouch network. Is there such a thing as an ex-president podcaster privilege? Because that's all that's left based on the relationships and the timeline. There's no presidential executive privilege because Bannon wasn't in the White House at the time. He was no longer a special assistant to the president, and Trump was no longer president. So those issues were all up for grabs. Nichols allowed the jury to convict because his interpretation of a 1960s case that's precedent, prevailing law, if you will, controlling law in the District of Columbia, stood for the proposition, and it's still on the books, that there is no defense, if you will, to flouting a subpoena of Congress. It's whether you just intentionally did or did not do something. And if you did or did not do something, that's it. You don't get to use, well, my lawyer told me to do it, or this person told me to do it, or the president was the president, and all of that. And so that issue of whether there is even an ability to assert the privilege, let alone whether Steve Bannon was entitled to it, was up for grabs at the time of sentencing. So the judge cut Bannon a little bit of slack and said, why don't you stay out on appeal? Don't go to prison. Don't serve your 4 months, because you can see how long this is taking. We're now 15 months from his conviction, and we're just getting to an appellate argument, an appeal with a 3-judge panel randomly selected of the D.C. Court of Appeals. And so he would have already served, if he went to jail, he would have already served the 4 months and still be waiting another 11 for his appeal to wrap around. And the judge said, why don't you stay at home for now? And if you lose, then you're going to have to go in and do your 4 months. So we just had a hearing this past week, 3-judge panel of the D.C. Court. You got Justice or Judge Garcia, a Biden appointee, Justice or Judge Pillard, an Obama appointee, and then Judge Walker, a Trump appointee. But even the Trump appointee was negative towards the position taken by Steve Bannon. Their main argument at the appeal was that Bannon got advice, bum or otherwise, good or bad advice, from his then lawyer, Robert Costello. Now, the lawyer, let me just give you the incestuous nature of all the cast of characters here related to Bannon and his appeal. His lawyer for the appeal was David Schoen, S-H-O-E-N. David Schoen was also the lawyer for Donald Trump in one of the impeachment hearings in trying to defend him. He also got fired at one point by Bannon, and Bannon said on his podcast that he would never use Schoen again. And now Schoen is right back being the advocate for Steve Bannon during the trial. The lawyer that Steve Bannon claims that he relied upon for the I didn't respond, or I ignored or flouted the congressional subpoenas, 2 of them, for testimony for documents, because my lawyer, Bob Costello, told me to do that. Now, some astute audience members might be thinking, where do I know that name from, Bob Costello? Well, you know it from a couple of places. One, at one point in his life, he represented Michael Cohen in matters, and then testified against Michael Cohen in before the grand jury before Trump was indicted in the Stormy Daniels hush money cover-up affair and books and records fraud. Also, more recently, Bob Costello, who was Rudy Giuliani's law partner, had defended Rudy Giuliani in his losing defamation case down in the District of Columbia, brought by Shane Moss and Ruby Freeman, two Fulton County, Atlanta election workers who sued Giuliani and others because they were accused of participating in voter fraud when they were not. That's the same mother-daughter team that's at the heart of the Georgia election interference criminal case as well. That Bob Costello is suing Rudy Giuliani for over $1 million in unpaid legal fees. And now that's the guy that David Shawn, in his oral argument about Bannon, is pointing the finger at, saying Bob Costello, right or wrong or indifferent, whether it was good advice or bad advice, told my client not to testify. And more importantly, told my client, Steve Bannon, that Donald Trump had told Costello that he was invoking executive privilege and that he should not, instructed him not to testify.
I'm not sure I follow that, because, there's a lot of activities in life where someone might have a deadline and they might be punished for missing it, but then they might still have an obligation. I mean, tax returns, there's all kinds of things where there are consequences for missing a deadline, but the duty to comply and the utility, in this case, the utility to the committee of having the testimony persists, even though there may have been a default. So I'm not sure that I follow that it, first of all, it's in the record that Thompson continued to want the testimony. So I'm not sure why you would need any further. Nobody's really denying that, but it's more, you're raising an inference, or you're drawing an inference from that I'm not sure it supports.
Your Honor, a related question would be why the committee refused to accommodate. There's a constitutional mandate under U.S. versus AT&T to try to reach an accommodation. In this case, what Bannon said through Costello to the committee was, Costello said, Bannon's hands are tied. Privilege has been invoked. He cannot comply. However, if you resolve privilege with Trump or get a court to order Bannon to comply, he will comply in full. Secondly,
does it matter under that theory whether the former president or the incumbent president had communicated any assertion of privilege to the committee?
No, Your Honor, it does not.
It doesn't matter. So any lawyer can say, I'm speaking for the president here. I don't have anything to show you, but talked on the phone to someone and they're asserting privilege. When you look at the past cases, like, take the Myers case where there's a detailed district court opinion by Judge Bates, there typically is a formal assertion.
Typically, Your Honor, yes. But in this case, we also have, by the way, the ratification, let's say, the confirmation by President Trump in a letter later confirming. It's
not available when you're talking about the sort of ex ante obligation to accommodate. And I'm thinking about, whose burden is it to make the next foray into a process of accommodation. And the committee has served a subpoena. And typically, I think the deponent would then turn around and proffer some kind of, well, I'll answer, all these other questions, but can we reserve questions about my communication with the former president or something? But I don't see in the record that there was any response other than.
And so that met with a lot of skepticism by the three-judge panel. First of all, fundamentally, they were not buying an oral argument that a former president holds the executive privilege. And they are more in line with the case law that says, almost an unbroken chain of case law, that says that the sitting president, whoever that is, holds the executive privilege, and that was Joe Biden at the time. That's one. Two, they all acknowledge that and ask questions, pointed questions at Steve Bannon's lawyer about, well, your guy wasn't even in the White House. He was a podcaster at that time. So how do you even have the right to assert the privilege? And there was some tap dancing by David Shawn related to that didn't really help his case. Even Judge Walker, a Trump appointee, questioned how would you even assert the attorney-client privilege since you don't even know the questions that are being asked because you never appeared in front of the in front of Congress, because you have to assert the privilege question by question. And how did you even know? So it's not every question they would have asked you would that privilege have been asserted. So I don't think that gives you a defense to flouting the subpoena by Congress. And so when even the Trump appointee is not on your side, you know things are going rough. So let me just give you the prediction at the end of this hot take here. Based on the questioning of David Shawn and his answers, I would find it highly unlikely. In fact, I think it is very likely that either a 2-1 decision or 3-0 in favor of the government is going to be handed out in the next 90 days. And at that point, if Steve Bannon loses, if he's on the losing end of a 2-1 decision or a 3-0 decision, at the end of that, he's going to have to go in for the 4-month suspended sentence, unless he gets the U.S. Supreme Court to take him up on an appeal. And he'll have to go through Chief Justice Roberts, because Roberts is the judge of the Supreme Court, the justice of the Supreme Court, that is the duty judge or administrative judge over the District of Columbia. So he's the gatekeeper. He looks at the papers and says, either I'm going to make the decision right now that I'm not going to stay the emergency application to not have Mr. Bannon go in and serve his time. And if he doesn't want to make the decision on his own, then he has to refer it over to the full 9-member panel of the full panel of the U.S. Supreme Court. But my prediction here is that whether it's 3-0 or 2-1, Bannon will lose his appeal. He'll then be staring at an order to report to the Bureau of Prisons to serve his 4 months. At that time, as I joked on Legal AF, he will not be able to podcast. He's not going to be able to use his 20 minutes a week on the phone privileges from jail to do podcasting. I'm sure there's going to be limitations placed on him while he's in the confines and supervision of the Bureau of Prisons. So he'll at least be off the air for the next 4 months, unless he gets an emergency appeal and stay granted by Justice Roberts, and then a decision by the full Supreme Court. You need 4 members of the Supreme Court of 9 to agree to take up a case on appeal, and then they can decide the case at that point. And maybe there's 4 members of it. I mean, it is a right-wing MAGA-leaning court. However, when it comes to Donald Trump and things like ridiculous assertion of executive privilege, they really have not sided with Donald Trump at all, and they've denied most of those kind of requests. I mean, the thing that the appeal ultimately founders on is that there is established precedent in the District of Columbia since the 1960s that says no defense, let alone a reliance on defensive counsel, is going to undermine the conviction for these particular willful refusal to comply with congressional subpoenas. So therefore, I think Judge Nichols will be, as a trial judge, affirmed by all of these courts that he did the right thing, not allowing that defense to go to the jury, because it's not a defense under the current state of the law. And I think we'll see a reaffirmation of that 1960s legal controlling precedent, and then particularly new additional rulings that will then be used by future prosecutions and future defendants that'll be called U.S. versus Bannon, which will update this case law from the 1960s. We'll keep talking about these type of important issues at the intersection of law, politics, and justice. One place, the MeidasTouch Network. You knew that. You're watching me here. And then if you like this, give me a thumbs up. It helps with the ratings. Every Wednesday and Saturday, we curate the best of the stories at the intersection of law, politics, and justice, and we bring it to you on Legal AF. It is exactly what you think it is. It's every Wednesday and Saturday. And the co-founders and leaders of Legal AF have collectively 75 years of legal experience, and we bring it to you just the way I did it now. We don't blow smoke or sunshine. Help the MeidasTouch Network, a grassroots network, get to 2 million free subscribers. The bigger they get, the more your voice is heard. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.